a magazine published a semi-nude photograph of a woman in a campaign against breast cancer. The tagline of the photograph was to encourage women to get regular medical tests done to ensure early detection of the disease. So this is the object, and the object is relevant. That's why they are telling us the object. A respected lawyer in Delhi felt the photograph was obscene and would result in young minds being corrupted. Hence, he filed a complaint against the editor of the magazine, invoking Section 292 of the Indian Penal Code. In the light of the recent Supreme Court jurisprudence on Section 292, which of the following is not a standard that should be used to judge whether the photograph is obscene? So the central question here is whether the photograph is obscene. And to decide this question, certain standards have been involved or prescribed by the Supreme Court through certain judgments. There are 4 options as usual. The picture has to be viewed in the background in which it is shown and the message that it seeks to convey to the public and the world at large. So the message and the background is to be considered. Second, if the picture has the effect of depraving or debauching the minds of the persons who may see the picture, it would be obscene. Thirdly, in judging whether a picture is obscene, contemporary mores and national standards should be considered, and not the standard of a group of susceptible and sensitive people. And the 4th choice is none of the choices. Now, there have been 2 recent judgments. Earlier, the Hickling test was applied for determining obscenity. Hickling test is a legal test for obscenity established by the English case of Regina versus Hickling. But this test is nowadays not applied. And the Supreme Court has elaborately explained that the nude is not obscene within the meaning of Section 292 of the Indian Penal Code. Just because the picture is nude or semi-nude, by itself it does not establish obscenity. And the judgment which we are now going to consider is particularly significant because it expressly rejects the Hickling test, and the Supreme Court of India has instead applied the Roth test, which is also known as the Community Standards Test, which was evolved in the US. In contrast to the Hickling test, which was focused on individual or isolated aspects of an entire work that could be deemed obscene, as well as its impact on vulnerable sections of society. Hickling test related to vulnerable sections of society. But under the Roth test or the Community Standards Test, the court adopts what it calls the Community Standards Test, that a picture of a nude or semi-nude woman as such cannot per se by itself be called obscene unless it has the tendency to arouse feeling or revealing an overall overt sexual desire. Only those sex-related materials which have a tendency of exciting lustful thoughts can be held to be obscene. Nudity by itself is not obscenity. Then came the case of Avik Sarkar and another versus State of West Bengal and another in 2014. This is an important judgment, a milestone judgment on Section 292 IPC, Avik Sarkar. Just remember this case. The court in this case observed that while judging a particular photograph and the article of the newspaper as obscene, regard must be head to the contemporary mores and the national standards and not the standards of a group of susceptible or sensitive persons. This is the phrase or the language used by the Supreme Court in Avik Sarkar, and you will notice that in our question, option C has the same language, contemporary mores and national standards, and not the standards of a group of susceptible or sensitive persons. And the court thereafter said that we will have to apply the community standard test rather than the Hickling test to determine what is obscenity. So for exam purpose, please remember this case, Avik Sarkar versus State of West Bengal 2014, and the standard which was laid down by the Supreme Court in this case is known as the contemporary standards test, and the Hickling test was discarded. These are the highlights of this case. Further, a picture of a nude or semi-nude woman as such cannot per se be called obscene unless it has the tendency to arouse the feeling of or revealing an overt sexual desire. This we have already seen. Then in 2015 we had the case of Devidas Ramchandra Tuljapurkar versus State of Maharashtra, where also the Hickling test was not adopted and rather the test prescribed by Avik Sarkar was followed.